Good morning and welcome to the third episode of our new webinar series, Commercial Collections Corner, touching on all things commercial collections. Today's topic is how the litigation process can help assure a successful outcome. My name is David Wolfe. I'm a shareholder here at Weltman, and I will be the moderator for today's session. I've been with Weltman for 25 years, and I'm licensed in both Michigan and Florida. And during my time with the firm, I've handled many different types of cases. I started my career handling consumer matters where I focused on replevin, claim and delivery, or collateral recovery. And since 2014, I have served as the managing attorney for our Michigan office. I've been doing commercial litigation for the past 10 years. In 2018, I took the Florida bar exam, and since late 2018, I've handled the firm's commercial and consumer litigation in Florida. Since 2022, I have practiced exclusively in Florida. Now that's some background on me. Now, before we get started, I would like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording will be sent to all attendees. Also, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars. Over my 25 years, I've worked my way through many different types of claims, a majority of which involve basic promissory note, guarantee, loan documentation. I'm also familiar with different types of financing arrangements that our clients utilize, including the bank loans, debt buyer, debt servicer arrangements, merchant cash advance, and others. Most loan documents are uniform, and over 25 years, I've seen most claims before. But I'm a litigation attorney, and sometimes the issues or claims are unique, and that's where we like your input. I personally like your input. To be honest, what I tell my clients is, you know your business better than I do. We are well prepared to address straightforward promissory notes, demand notes, guarantees, but sometimes there are documents that are a little bit different, and we'll go through some of those. But really, this webinar is about what our clients can do to help us be successful, and your involvement is key to that. So our client involvement starts before the file is referred to our office, and we want you to help us understand what you want to accomplish. It's easy to say, go collect the money, and that's our strong suit. But if there are special circumstances, we'd like to know what they are. So when I think about a file, I first look at the parties, and I would encourage my clients to do that as well. Who are your parties? Where do they live? At the beginning, the only information I have is what my clients provide. So if the defendant has moved out of state or into another county within the state, that could cause issues and delays. As many of you may know, in a consumer matter, if our firm is required to sue the defendant where the defendant resides, in the county where the defendant resides. So if they're residing in Oakland County, for example, and they move to Macomb County here in Michigan, we'd like to know that, because that's a immediate violation of the Fair Debt Collection Practices Act in a consumer matter if we were to sue them in Oakland County when they really resided in Macomb County. Also, what type of debt is this? Is it a consumer matter or a commercial matter? Because where the defendant resides is absolutely important in a consumer matter, and there's some importance in a commercial matter, but on the commercial side, it's not a violation of the Fair Debt Collection Practices Act to sue the defendant in the wrong county, and we can get around that quite easily. Also, is a business one of your defendants? We then look at, is the business open and operating, or is it active or inactive on the state's website? So as you know, as many of you know, the states maintain a website where you can search the business name, and it will tell you if procedurally the business is still an active business. It might have been dissolved because they haven't filed a annual report for a while. I see that quite often, but that doesn't mean they're either operating or not operating. So if they're active on the website, and they're out of business, or it's just a, kind of a mom and pop shop that they close down, it may take a while for the state's website to be updated if they don't file their annual reports, and they haven't moved to dissolve the corporation. Um, so we'd like to know a little bit about the business if you have a business. And again, is it open and active? Is it operating? Is it really a viable business? Because it doesn't make a lot of sense if the business is dissolved and shut down to file suit. Now, there may be some exceptions to that, and we would be glad to address those with you, but I would like to know before we start filing the case. And we do our own research, but sometimes it's better coming from you, because our clients, because you've had the most recent contact with the business. Additional parties, right? So we have a lot of times, most of my claims are really the promissory note and a guarantor or two. And so, but I have seen other parties crop up in discovery. So we issue some discovery, and then it's disclosed to us that there's another liable party out there that we weren't advised of. And it's important to know, so that we can name all the parties in the initial lawsuit. And it's my belief that if the more pressure you bring on the defendants out of the gate, the better results you're going to get. So we like to know all the parties that you have. Also, do you have a deceased customer that we may not see? So when we open our file, our system will scrub for both deceased customers and bankrupt debtors, and but we may not know right away. So it may take a day or two, but if you know that the customer is deceased and you could let us know, that would be helpful. A lot of times we will still file suit, and in a situation, let's just say it's a replevin situation where your customer had purchased a car and financed it through your organization, and that customer has since passed away. Somebody's out there driving the car, and you may not know who it is, and we may not know who it is, but we will still file against the deceased customer to see if we can get information during the litigation process as to who's now driving the vehicle. It's probably a family member or something like that. Also, bankrupt debtors. If the debtor has filed bankruptcy previously, and what happened? Again, our system will scrub for that, but we'd like to know if they filed and what happened to that previous bankruptcy case. So it could have been dismissed, it could have been discharged, there could have been a reaffirmation agreement entered into, there could be a non-dischargeability order entered that we'd like to know as well from you. And then I would look at the documents that you have. Usually, again, as I indicated, we file suit on a lot of promissory notes or demand notes, and there is a difference between a promissory note and a demand note. A demand note is payable upon the financial institution's demand, whereas a promissory note might have a maturity date. So we'd like to have those documents. I think I got a new file today where I don't have the note. I don't have the retail installment contract or the promissory note or whatever, and we have to go back to our client and say, hey, we need that. So when we're setting up the file, we're looking for those documents, the note or the contract that imparts liability onto the defendant. In all jurisdictions that I know of, especially in Michigan and Florida, we must attach that document as an exhibit to our complaint. A lot of banks, when we have more sophisticated deals, business deals, they have additional documentation that goes along with it, a business loan agreement, and that usually contains a separate set of covenants, which I like to use in discovery to review the debtor's books and records. A separate security agreement maybe that would give us access to other collateral that we might be able to attach to help recover the debt. And then guarantees, especially where there are multiple guarantors, we would like to see all the guarantees so that we can make a decision as to whether we need to add additional parties to the lawsuit. Loan modification agreements are popular. So we have some clients that, especially financing trucks for some reason, the truck drivers, owners of the trucks, fall onto hard times, can't make a payment. The client will modify the loan agreement and through a separate document to push payments to the end, or however they do it, and that changes the terms of the contract. So it's an addendum to the contract, really, and we need that to attach to our complaint, especially in Florida, which says that we must attach the contract or the document that imparts liability onto the defendant. Forbearance agreements I've seen pop up later. We haven't gotten them on the front end, and then later the defendant says, "Hey, wait a minute, there's a forbearance agreement in place that may change the terms of the loan, or it may add additional liable parties or even collateral." So somebody falls into default, and the client then enters into a forbearance agreement where they agree to not pursue collection of the debt, but in exchange, the debtor gives up some things like maybe defenses to the action, that it adds additional parties. Maybe there's a new partner in the business, and they want to bring them into the liability as well. So we like to see all those documents, and we ask that you provide those to us ahead of time. And then there may be additional issues that might affect your claim. So I referenced bankruptcy and the possibility there was a reaffirmation agreement or a non-dischargeability order that might affect our client's ability to recover. Reaffirmation agreement might just simply reaffirm the debt, and we would attach the reaffirmation agreement as the contract, but it also could change the terms. So if the client was willing to take something less on the full balance, and then with payments at a set amount, we would need to know that. Otherwise, we could be in violation of the discharge injunction. Non-dischargeability order too. Many debts in bankruptcy can be non-dischargeable, and our clients may have had counsel that negotiated a non-dischargeability order before our involvement, and we'd like to see that as well. Bankruptcy, in the bankruptcy, the debtor could have received a discharge, so that would certainly affect our ability to collect any remaining money owed, but it may not affect our ability to go after collateral. So I had one yesterday where I spoke to a defendant. She's residing in an RV down in Florida, and we're trying to pick up the RV, and she had filed bankruptcy. And when I was talking to her, it didn't occur to me, and I stopped for a moment and thought, oh, I better look at my complaint and make sure I didn't pursue her for money damages too. And I didn't. I had seen it when we had filed the complaint, but I can tell you that months down the road, I'm not going to remember that I saw that. So I had to check my complaint and make sure that I was only pursuing possession of the unit versus the money damages as well. And then again, I think I mentioned this earlier, we want to look at the types of debt that are at issue here, whether it's the debt is commercial or consumer. And I know we do some work for equipment financiers, and sometimes they finance personal use equipment, maybe small engine machines for the home use, lawn mowers or snow blowers or something like that. That would be a consumer debt, but still fall under the same client, who is really a commercial finance company. And then we would like to know the outstanding collateral. What type of collateral? I can tell you, I deal with a lot of vehicles, both cars and RVs and boats, and those are kind of run of the mill. But lately, I've been getting things like kitchen equipment, a paint booth I saw come through, and I'm not sure what that is. Again, right? I'm a litigation attorney. I don't know everything that my clients are involved in. I know a little about a lot of things, but not a ton of in-depth of knowledge about what the collateral might be that's used in that type of business. So is a paint booth something that's built or is it removable? Does it become a fixture? So that's why I think, in the commercial kitchen equipment, the same thing. Are these considered fixtures? That's an important designation. Boat engines and trailers, we've seen those. Engines for boat engines have a separate VIN, and so we have to name that specifically in the complaint. The trailer that the boat rides on might be a separate piece of equipment as well. We would need to know all that. And separate security interests. So I had a case a few years ago where I represented a bank who had a debtor up in Traverse City, and it was a small shop, and they had a husband and wife as guarantors. And so we sued for the unpaid money, and it was a significant amount of money. It was 70, not too bad. It was about 75,000. And later through the discovery process, we learned from our client or from the defendant that that our client had a first mortgage on the real property. Now we went back to the client and said, well, would it be better? Would it be more effective to foreclose on the property? And so we were working that out. We were thinking maybe we would move forward, and foreclose, because in a foreclosure action, your remedies are exclusive. So if you're suing on the note, you can't both sue on the note and foreclose. If you're foreclosing, you can't sue on the note. So we were thinking how we were going to do that. In the meantime, we had mediation, and I was glad I had the mortgage, because when we went to mediation, we sat in the mediation room, and the debtors said to me, well, we need to leave around noon because we had a flood in our property, and the remediation folks are coming to take a look at what it's going to take to remediate the property and get the flood damage fixed. And so when they left, the debtor's attorney was very difficult to deal with, and he was giving us a very low ball settlement offer, and they can't afford it, and they're going to file bankruptcy, and then they're going to appeal any decision we get, and the defense was really based on some obscure statute of limitations found in Article 2 as opposed to Article 9. Anyway, we were talking with the mediator, and the mediator said to me, well, do you really want to take back? I mentioned the mortgage, and the mediator said, do you really want to take back a flood damaged property? And I said, well, I think they're going to have it repaired by the time we get to it. So I think it's probably a better recovery for us. And given that they had the property on the hook for as security for repayment of the debt, we were able to get our client fully paid, and actually with some attorney's fees too. So knowing what collateral secures repayment is very important. So. And then vehicle title lien issues. So oftentimes now, and this came up as somebody posed this as a question too, what do we do about our vehicle lien not being properly perfected? So knowing this ahead of time, I file what's called I would file for the replevin action, money damages. My recommendation would be file for the replevin action for money damages and possession. That's permitted in both Florida and Michigan. And then I would add a count of declaratory relief, advising the court that the client's security interest was attached to the security, but it was not properly perfected, and then request an order from the court directing the Secretary of State to issue a new title with our client's lien showing his first and best on the title. So we've done that a fair number of times, and that works out pretty well. It's as expedited as you can get on that. So knowing that vehicle title lien issue is out there is great, because the client may already have the vehicle repossessed and sitting in a lot somewhere. It's just not perfected. So we can help out with that. So I hope that answers that question. But if you have any additional questions on that, feel free to email me or put it in the chat, and I can expound on that a little bit. And there are other issues. So moving on to additional issues that might affect your claim. There may be factual issues that affect it. So before it comes our way, you may have received information from either a third party or your customer that there's fraud or identity theft involved. So did I, a few years ago, I had a case against a dealership. It came down that, and we were suing the defendant, and he claimed that, well, I didn't sign this and I didn't know anything about it. So the dealership was in Dearborn, Michigan, and he resided in uh, uh, Georgia. So he sent us the information, and we were able to go back to the dealership and say, well, you have an obligation, dealership, to make sure that my client's lien is properly perfected and that you deliver the vehicle to the correct person, or the person that's described in the retail installment contract. I don't know whether the client knew that ahead of time, but certainly it came down later. We were able to get fully paid on that one too, because the dealership recognized that they had an obligation to repay the client. Threat of violence. So I did some work for a bank a few years ago that had what they called a threat of violence department, and I would handle their replevins. And whenever a debtor either push back or threaten violence, it would come my way. So I knew from that client that every case I got was going to be challenging, whether they were sovereign citizens or they just didn't want to give up the vehicle, whether it's a motorcycle or a boat or whatever. I would get those claims, and I would know that I had to proceed with be very careful about how we proceed. And we were able to address those very well, I think, for that client. But knowing that ahead of time helped us describe the right, or decide on the right approach. So, and then again, you want to understand your contract and its available remedies. So many contracts today include venue or jurisdiction clauses. Now, many states, and Florida and Michigan included, provide a venue provision in the statute that says we can sue any defendant. So if we have multiple defendants, we can pick a defendant and sue them where they reside, or where the contract was signed, or where the breach occurred. But a venue jurisdiction clause may say, well, all claims have to be brought in, the state of Virginia, in this county, in this court. And that would be a good defense to our case. We file it in Florida or Michigan, and the debtor raises the issue of the venue jurisdiction clause. Now, I think our office does a good job of identifying those and getting back with the client, but knowing that ahead of time saves us that potential issue of us just reading over and not catching it. Arbitration clauses. There are many contracts that contain a mandatory arbitration provision that any claims have to be arbitrated. Knowing that ahead of time would save, well, at least we would be in communication with our clients about whether it makes sense to file it or arbitrate it, file a complaint in state court or arbitrate the claim. Arbitration can be more expensive, but it is faster. And we have a lot of experience with arbitration in Florida and other states. And we can help our clients understand whether it's cost effective to go the arbitration route. And attorney's fees provisions. So now this is unique. This problem is unique in my mind to Florida, because Florida has the reciprocal attorney's fees statute. So if the claim is a little bit on the edge, right? We don't know if the last payment was really a true voluntary payment, or maybe it was some sort of credit to, like the payment got a refund of insurance. I've seen that in the past. That may affect the statute of limitations, because a refund of insurance fees is not a true payment. So if we're not sure about whether the statute of limitations, and I'm using that as an example, but there may be other reasons why the claim is on the edge of being, can we file it, can we not? I would want to talk to my clients about the Florida's reciprocal attorney fee provision, which says that, which allows the courts to award reasonable attorney's fees to a prevailing party in a lawsuit, even if the contract only provided for attorney's fees to the other party. How does that work? If a contract states that one party pays the other party's attorney's fees if the other party wins, then the court can award attorney's fees to the prevailing party in a suit to enforce the contract. So your contract says, bank, credit union can and collect its attorney's fees from you if you default, defendant. That can be used against you if you don't prevail. When it applies it applies to contracts that allow attorney's fees to a party when they enforce the contract. It does apply to credit card agreements and mortgages specifically. There are exceptions available, but it should be accounted for during the claim preparation stage. So understanding that, if the debtor opened the account in 2020, then we're not bumping up against it. Well, we might be, let's say 2022. We're not bumping up against any statute of limitations period for breach of contract, which is 6 years in Michigan and 5 in Florida. So we don't have to worry about it. But if the last payment was done, the car was repoed in 2020, and no payment has been made for a few months before that, now we have a problem. We wouldn't want to file that and run into the debtor's attorney being able to collect attorney's fees from our client. So that's an important consideration, that if we have all the information, we can make an informed decision about how to approach that file. So once our file is set up in our office, our first steps in the litigation process include preparing the complaint. Michigan is what's called a notice pleading jurisdiction, and Florida is a fact pleading jurisdiction. That means we have to include specific facts in our complaint to establish our claim. Fact pleading requires a short, clear statement of the facts that establish the plaintiff's claim, a clear statement of the grounds for the court's jurisdiction, and a request for the relief the plaintiff is seeking. Now, our complaints do that, but and almost all of our cases are based on a breach of contract. So we must show the existence of a valid contract, the defendant's breach, and damages. And it's important to know any facts that might affect these elements. So modification agreements, forbearance agreements, bankruptcy, deceased member, active military, all of that might go into whether any of these three elements are affected, right? So these steps are important to help us pursue your claim, and many of you use our referral forms where we try to solicit this information. So for consumer debts, the referral form asks you to break out the Reg F information to allow us to send the model validation notice, which is required. So we're asking for, Reg F talks about the itemization date. We need to know from you, is the itemization date, your balance calculation, is it based on the transaction date, which would be the date of the contract? Is it based on the date of charge off? Is it based on the date of breach? And then your balances might vary because of that. So we're asking you for all of that information so that we can send out an accurate MVN, model validation notice, and hopefully get the debtor's attention and call and try and get this case resolved, right? So once the complaint is filed, the next step is to send it for service, and that's the biggest challenge. I can tell you, it's the biggest challenge I have in Florida. Florida requires us to serve a debtor personally or by substitute service. So, and they give us a short turnaround time. So Michigan, it's 91 days. Florida has 120 days, and the dates can be extended, but you got to show you got to show that you made some efforts in that time period, and it's an additional motion, it's additional work. But if we can show that we're making efforts and we think the debtor is evading service, that's more helpful than if we just had one address and we tried it on day one and we weren't able to get anything else. If the processor went to the address and it's vacant, for example. So to perfect service in Florida, we have to serve the defendant personally, which means hand a copy of the summons and complaint to the named defendant. That is the most preferred method, I think, both in Michigan and Florida, and probably in other jurisdictions that I'm not aware of. But that's how they want it served. But Florida allows us to also use what's called substitute service, where we hand the person a copy of the complaint to somebody who's 15 years or older living in the household. But that statute requires us to capture the occupant's name. So if it's their son John, for example, and he's 17, he's got to give us his name, and a lot of times these people are not willing to give that to us. So it's more challenging to get substitute service done. It's more challenging to defend substitute service than actual personal service. Now, contrast that with Michigan, which provides for what's called alternate service. So if personal service cannot be perfected, we can move for alternate service, which allows us, if we can show the court that we made separate efforts on separate days at separate times. So if you go out to the defendant's house 3 Mondays in a row at 9 o'clock, well, they're likely at work if they work in a 9 to 5 job. Versus you go out on Monday at 9 and Wednesday at 7 in the evening and Saturday at 2 in the afternoon. The courts like to see that varied attempt. They like to see what's called a postal check. We run that with the post office to see if they're still receiving mail in their name at that address. And then we can apply for an order that would allow us to post it at the address where the defendant resides. So if we think he's at 123 Main Street, we show 3 separate attempts at 3 separate times, along with a postal check that says, yep, he's still getting mail at that address, and no neighbor has come out and said, oh yeah, he moved away 3 years ago, or somebody comes to the door and says, yeah, I'm not that person. Then we can get an order for alternate service. That's simply not available in Florida, unfortunately. And Florida is really very focused on service of process. We had an order to show cause the other day on a replevin matter, and the defendant showed up to the hearing, and the judge said, well, were you served? And that person said no, and so he's challenging whether our service was appropriate. In a replevin matter, we can post the order to show cause at the address where the defendant resides, just for the purposes of getting a writ of replevin. And my answer was to the court was, well, they're here, so obviously they got notice, but it's not enough to get notice. You actually have to follow the statute, and it's strict construction in Florida. So it's a challenge to getting service completed in Florida, more so than in Michigan, and probably even Ohio at that level. So for these reasons, I like to have all the available addresses up front. So we send them to our process server and say, okay, try 123 Main Street, and this address and that address, and then we get them back, and they, either they got them served or not. And sometimes it generates additional leads on address, and we'll continue to skip trace, but we like to have all that information from our clients so that our process server is making attempts at the appropriate times, at the appropriate addresses. And we try to communicate with our clients the issues that we're having with service as soon as we're aware of them. It's a bit of a challenge to get our process server to give us information on why they think an address is bad. I've seen communications that, we hear people, the process server goes to the door and they knock on the door and they hear people moving around, but nobody answers the door, and we get, oh, that's a bad address. Well, I don't know that it is, so we go back to our process server and say, okay, can you give us a little more information? Do you think, and then also, what do you recommend? Do we stake out the address? Do we, and then if that's your recommendation, how much is that going to cost? And then we try and take that back to our client and say, okay, we think he's living at 123 Main Street. We have no reason to think he's not. And, the process server is offering to stake out the address and wait to see if they come and go, and he'll sit there for 4 hours for X dollars. Now, certainly some cases warrant that sort of additional cost, and some cases don't, but we leave it to our clients to make that determination. And that's why we ask for all the available addresses that you have, so that we can provide those to the process server, and we can exhaust those before we get to day 120 or 91 or whatever it is. Uh, Following along, if there's no answer filed, we'll file a motion for entry of a default judgment, and the courts require supporting affidavits to establish damages. And we try and send the affidavit early so we can get it back signed from our clients before we're ready for it. So a lot of times our affidavit will establish damages, but it may also need to establish the documents, because the documents themselves in just a in an evidentiary sense are what they call hearsay, but there's an exception to the hearsay rule for business records, but we have to establish the business records. So our affidavits will often say, the documents are, kept by our client in the ordinary course of their business. It's their regular practice, and they're kept for the purpose of their regular business activities. And then we can use that affidavit to provide the court with the testimony necessary to get to judgment. So we're reaching back out to you shortly after we file the case for the affidavit to sign and get back to us, so we can submit that with our defaults or default judgments. So if there is an answer filed in the case, then we're looking at the answer for merit. So I always tell my team it's usually one thing in the answer that sticks out in any answer. There's one I got the other day. It was we're trying to get back a Rolls-Royce Cullinan, and the defendant put in there that, yeah, he signed the agreement. It was a retail installment contract. He signed the agreement, but he didn't know it was a retail installment contract. He thought it was some other financing arrangement. Well, that's an answer without merit. You admit you signed the agreement. Its contents are you should know the contents of what you're signing. And so I've immediately filed a motion for summary judgment. It's a $400,000 car, so we want to get that back. But there are other defenses that are a bit more in depth, right? A fraud, identity theft might be a defense, and we would pass that along to you. We would pass these along to you when we see them and say, hey, do you have any information on what he's saying here? Is there any merit to this defense? So fraud, I didn't sign the contract, or or it's ambiguous, right? My spouse is responsible for the debt. Well, that's not identity theft. That's maybe a divorce judgment that comes into play. So if we can discern that there's no merit, we're going to move on, but we want to send it to you for your input as well. Other party liability, the dealer is the source of your damages. Misrepresentation, auto dealer representations. Under the Retail Installment Sales Act, they have this act is in various states, including both Michigan and Florida, I know for sure, which basically says that the finance company, whether it's a bank or a credit union or whoever takes assignment of a retail installment sales contract, is liable for the claims and defenses that can be raised against the dealer. So if the dealer said, I don't know, this car has no miles on it, for example, and it was a odometer rollback, that could be used against the bank or the credit union for sure. And we would want to know, and in that case I was describing with the car dealer, that was kind of the same issue, was that the individual we initially sued said, I didn't sign this, and so we had to go back to the dealer and then name the dealer in that complaint, so that we could get to a liable party, because certainly the guy from Georgia was no longer liable, and we needed to get to a liable party. Commercially reasonable sale is a pretty good defense in my mind. It's hard to prove commercial reasonableness, and there are some things we can do in Florida, in Florida especially. There's a specific Article 9 provision that says if the defendant fails to raise commercially reasonable sale, it's not the creditor is not required to address it. So you can't come back later at trial and say, well, wait a minute, they didn't sell this unit in a commercially reasonable manner. Statute of limitations, again, right? We would pass that along to you and say, hey, he's claiming statute of limitations, unless it's clear on its face that that defense has no application. Again, the contract was signed within the 5-year period. We're going to want to know a little more information. We want to make sure that the payment is truly a voluntary payment, and that it is going to toll the statute of limitations. Accord and satisfaction, I get this one a lot. Usually I can dispose of that pretty quickly. That basically says I made an agreement with the, I made a new agreement with the creditor and I paid it. Well, okay, it has to be in writing. There's the statute of frauds for banking institutions that require any agreement to be in writing. So you got to provide that to us. Waiver release, those are basically the creditor released me from its claim, or they waived their right to collect. Again, that's probably that may be factually dependent. We would send that on to you as well. If we think that we need more information from the defendant, we're going to immediately send that over to, if the defendant has raised substantive defenses like this, we're going to send that on to you for your input. Or we'll just go straight to motion for summary disposition. In the case with the Rolls Royce I mentioned, I didn't go through discovery because I don't think his answer raises a substantive issue. That I think I can dispose of that in summary judgment. I'd rather get that done, filed, and heard before I have to start challenging it through discovery and all that. So I think time is of the essence in that case, but more than I need to, really focus on his defenses. So when we file our motion for summary disposition or summary judgment, we'll likely need a more detailed client affidavit establishing the facts, authenticating the documents, and establishing the damages. So again, we have to show the existence of a valid contract. We have to show there was a breach, and we have to show money damages. So through the affidavit, we can do that, but we also have to get the documents admitted into evidence. So again, setting forth the client's authentication of the documents as business records. So there are some steps under the rules of evidence in both Florida and Michigan, and I'm sure in other states, that say you have to say that the client representative has to be a custodian of the records, and they've reviewed the records, and the records were made at the time or near the events depicted by a person with personal knowledge, that it's the regular practice to make those records, that it's the records were made in the ordinary course of the client's business, and might be another element, but they're all spelled out in my affidavit. And then basically I reiterate the allegations in the complaint, and the defendant signed the note. He failed to make payments as agreed, and they owe us money, owe our client money. So that's the client affidavit we need back from you to basically say, okay, it's not me testifying in front of the judge, it's my client testifying. So if we have to go the discovery route, sometimes we can get discovery, sometimes we get discovery from the defendant, and sometimes we'll issue our own. So discovery consists of basically 4 types, right? There's interrogatories, which are written questions, and the client's signature. In Florida, the client has to sign the response. They have to verify the response. Requests for admissions, I like to use those in Michigan, not so much in Florida. Where in a request to admit, you're specifically asking the debtor to admit the very elements that you're trying to show. Admit you signed the contract, admit you failed to make payments as agreed, admit you owe my client X dollars. And if they don't answer those, in Michigan, our next step was a summary judgment motion, because all of our elements are established at that point. Another type of discovery is request for production of documents. So I got one, just the other day, that is asking for all the documents, or the loan documents that the dealership uses. So the defendant wants to know, all of these documents that are our client's dealership. And I think I can properly object to that and say that's for him to go to the dealership and ask for. We don't have that information. Depositions, again, a witness would appear. So if we're being asked to provide a witness for deposition, we're going to ask the defendant, what topics are you looking to depose our client on? Is it on this loan? Is it on training? Is it on, whatever the issue might be? And then we have to get back with our client to designate the appropriate person, to appear on their behalf. And so that's kind of the general discussion of discovery, but how we use it, again, I talked about request to admit. I like to use them in Michigan. I liked to use them in Michigan when I practice here. But in Florida, the judges are reluctant to enter a summary judgment based on the defendant's failure to answer request to admit. So I use interrogatories more and depositions to some degree. So our discovery to the defendant is designed to establish the elements of our case and refute any defenses. This is important if the defendant has denied any elements of our claim, and we like to get some discovery on commercially reasonable sale when that's raised too. So under a commercially reasonable sale, our clients have to send the notice, the notice of sale, and then in the consumer matter, they have to send the subsequent, hey, we sold your car, the deficiency calculation letter. We sold your car, we got X dollars for it at sale, and leaving this amount that's still owed. So we have to show that, and then we kind of ask them to admit that they got the letter, that they got the notice of sale, that your vehicle will be sold on this date and time, or on or after a date set, and then we provide that to the defendant, admit you got this letter, and then draft interrogatories around that as well. So I might say admit this, and then in my interrogatories I might say, if your answer is anything other than an unqualified admission, tell me why, right? So, I didn't get it. It was, never mailed. Well, then I can say, well, to the client, hey, he's saying he never got it. Can you show me where you mailed it? Because that's all we have to show. I don't have to show he got it. I just have to show we mailed it. So, document requests, going back to that, they can be quite voluminous. So, when I get a discovery response or a discovery request from the defendant on RFPs, first thing I ask for from my client is, can you send me your entire file? Now I get some pushback from my client. I get some pushback from my clients about, hey, we provided all the documents. Okay, but I don't know what I don't know, right? So sometimes I have all the documents that I could need. Sometimes I might need additional documentation. I just don't know what I have, what wasn't sent to me, right? So that's kind of my issue there. As the case progresses and we get through the discovery phase, we come up to the mediation or trial dates. Florida really likes to mediate cases, and we would need to provide, in both those situations, we would need to provide a client witness. I try in Florida. In Florida, at trial, we can often file an affidavit and to introduce documents at trial, basically setting forth that these are business records, and using the same affidavit I use in my summary judgment motions to set forth the documents that we, get them admitted into evidence, and then get the damages established, and basically we can put that in front of the court and say, okay, the defendant has to present a counter affidavit or some testimony that this is not accurate in some way. And I don't think it's sufficient to say, for a defendant to say, I just disagree with the affidavit. Well, I have an affidavit that's, basically from a disinterested party within the bank or credit union versus the defendant who's incentivized to not tell the truth. So that usually works out pretty well. So we're permitted to do trial testimony by affidavit, both in Michigan and Florida. So I try and use that procedure. But mediations, we do oftentimes need a witness. Florida's rules are specific to that a client has to appear in order to effectively mediate the case. Now, as soon as we get a notice of mediation or trial, we're sending it to our clients and saying, hey, please designate a witness. Let us know who's going to appear on your behalf. Here's the day, date, and time for that mediation or trial. Mark your calendar now. Doesn't matter to me if it's, a month out, a year out, I'm still going to give you the notice because I want this to be on somebody's calendar somewhere. So we need the client's participation in the mediation and trial process to some degree, right? Well, mediation for sure, and trial. And I can tell you, I do not like to try cases. I like to get my cases resolved. Number one, I don't like to bring clients in from out of state to waste a day or so if it's not by Zoom. And I like to get my cases. I don't sleep well before trial dates, so I like to have my cases done before we get to that phase. And then, of course, as we get to the end of the case in the post-judgment collections phase, we we have a need for the client's participation from what asset information do you have? It's hard for me to get information in the phase of the case, during the case, about the client, about the debtor's collectability. I can tell you that there are some covenants in commercial loans in the bank and in the business loan agreement that will say, we have the right, our client has the right to inspect your business records at any time, defendant. And I've used that in discovery to get collectability records because I get from defendants all the time, well, you have problems with your primary case, procedural or substantive, and by the way, my client can't pay. Well, either we have problems with our case or your client can't pay it. I'm not going to argue both with you. Defendant, I'm going to go in front of the court, get the issues of the case resolved, whether they're procedural or substantive, statute of limitations, all of that, and then just deal with the collectability on the back end. In Florida, we're permitted to, well, our judgments have what's called a form 1.977 that we attach to the judgment, and the defendant is required to provide that. But in my 7 years practicing in Florida now, I don't think I've ever gotten, I think I've gotten a handful back. So we have to file a motion to compel and get them in to provide that. But any information our clients have about where they're working, where they're banking, all of that would be helpful to us to know. So again, right, so all throughout the case, if we have our clients' participation and responsiveness to our questions, I think that really helps us get a better result at the end of the case. So I kind of wanted to outline that litigation process and sort of put what I think where the client has some involvement in helping us along. But certainly you may have other questions, and I would be absolutely happy to answer any questions you have. Feel free to put them in the chat here. I don't think I saw any additional questions. Let me check before I kind of start to wrap up a little bit here, but it's coming up on 11:53, and I want to thank you for attending our webinar today, and I hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when this webinar ends, and please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on various topics such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library on our follow-up email. Thank you again for attending, and have a great rest of your day. Thanks.